All right, hello students. We're going to do a quick overview of some information on trial court. Our goal is to talk about the competition structure at district competitions, courtroom layout, the flow of trial, bailiff responsibility, ruling on objections, and then also some common objections that you'll see. I forgot to introduce myself. So I'm Judge Atkinson, the City of Denton Municipal Court. I write the cases for the Texas competition, and then I also am an advisor for the National Judicial Competition as well. So if you see me at district competitions or at state, come up, say hi. If you have questions, then reach out or find me at state, and I can help you with it. So, all right, let's jump into it. Basic competition structure, each district is different, but you'll get a check-in early in the morning where you will check in by school. You'll get your name badges and your brochures, t-shirts if there's t-shirts. You'll wait around for your morning meeting. Typically that's in your group, so it'll just be trial court would meet together to get some final instructions, figure out which rooms you're supposed to be in, and then also get your first round assignments to know whether you're a plaintiff or prosecution or defense side, and then which room you're going to be in, and then who you're going up against. You'll have typically first and second rounds. You could be prosecution both rounds or defense both rounds or prosecution one, defense on another round. It kind of just depends. Sometimes you'll even get a bye round where you'll have a round where you're skipping because of the numbers don't work out to where everybody goes every time. So you'll get that information early on. You'll have lunch. Typically at lunch, you'll have voting for your delegates for state, who's going to represent your district for those specific elected positions at state. I encourage you, if you're year two, well, probably it might be too late now, but for next year to look into running for an office. Judicial has several offices now. So that's lunch. You'll come out of lunch and have, if you have a third and a fourth round, that would happen. And then finally closing ceremony to close out your district competition. It's a general structure. Some might have some changes. For courtroom layout, this is what kind of a real courtroom might look like. We don't have juries, which is what you'd see up there at the top of the picture over to the left. You'll have a judge, you'll have prosecuting attorneys, defense attorneys, your witness stand, and then the other witnesses would be behind you. If you are, I think most of us are meeting like at a school, a big school, so you'll just be in a classroom. You'll want to have it arranged to where the judge is kind of at the front of the room, can see everybody. The witness will be on the side that the prosecution team is on. If it's a civil case, that would be the plaintiff side. The bailiff will need to be within earshot, eye shot of the judge, not necessarily right next to the judge, but close enough up front so everybody can see the bailiff. Defense is on the opposite side from the witness. And then the witnesses that you're planning on calling are just sit behind the attorneys. Then once they're called, they'll come up to the witness stand. And then when they're finished, they'll come back and sit in their spots. All right, flow of trial. There'll be pretrial or housekeeping matters, opening statements from both sides. The defense can reserve their opening for after the prosecution's case in chief. So it will go down here if that's the case. Otherwise, they'll give an opening statement up here. Prosecution or plaintiff will present their case in chief. The prosecution will call their first witness. They'll direct that witness. The defense will then conduct cross of witness one. Prosecution will call witness two. That's their direct. The defense will cross the prosecution's witness two, witness three, and so on. If the defense has not opened, they'll open, and then the defense will call defense witness 1. Prosecution will cross. Defense will then call witness 2. Prosecution will cross. Defense will call their third witness, their student third witness. They'll conduct direct. Then prosecution will ask cross questions. Both sides close. You provide closing arguments. Prosecution goes first, then defense, then prosecution closes. They get to open and they get to close. They go first and last. And then there's the judge's verdict. Let's take each of those individually. Pretrial. Before pretrial, greet your evaluator. Ensure that they have your team's information. So you'll get a team number, and the evaluator will need to know your name, both of the attorneys' last names, and then your team's number. The judge as well, the evaluator needs to know your name and your number. Once pretrial gets going, the purpose is to make attorney introductions and get guidance from the judge on judge's special procedures. If the judge has anything special that they would want, you would ask at pretrial. Some common ones are, do we need to ask every time we approach a witness? During argument and statements, can we use the courtroom? Can we move about the courtroom? Some people call it the well, that area between the judge and the attorneys. Can we go into that space and walk around for our arguments, our statements? Make sure you stand when addressing the judge. I see attorneys mess that up here in pretrial. Once trial gets going, of course, attorneys remember when they're objecting to stand when they're talking with the judge. Sometimes in pretrial, they forget to do that though. So always stand, even pretrial, when you're talking with the judge. A chance to establish yourself as confident and comfortable in the courtroom. You get to hear your voice in that space, which is great. The judge in pretrial will swear in witnesses. The script for that. The judge leaves the room. The bailiff says, all rise for the Honorable Judge Judy. This court is now in session. Judge then says you may be seated. The court calls case number, State of Texas versus. Then for criminal case asked, is the prosecution ready to proceed? Prosecution says, yes, Your Honor, I am John Smith, along with my co-counsel, Jane Smith. We represent the state of Texas in today's trial, and we're ready, Your Honor. Judge says, is the defense ready? Yes, Your Honor. I'm John Doe, along with my co-counsel, Jane Doe, represent the defendant, Cameron Shepard. If you have questions at that point, you can ask the judge. We represent the defendant. We have a few housekeeping matters if you're ready for those, Your Honor. Judge will say, yes. What's your question? You ask your question, and then the judge will let you know on it at that point. But this is your chance to ask the pretrial questions. Judge then says, would all witnesses who are planning to testify please raise your right hand and repeat after me. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God. Witnesses say, we do. I think my camera's mirrored. We do. And that's pretrial. Witnesses then sit down, and we move into opening statements. Opening statements, each side gets 2 minutes. Under rules that are in effect in 2022. Introductions or opening statements are a chance to provide introductions and acquaint the judge with the nature of the case and what is expected to be proven. It's a chance to tell your side of the story. Prosecution goes first, defense can defer. We've already talked about that. Make sure you're warm, sincere, and authoritative, that your story is the correct one. This could be your first appearance of your trial theme, if you have a theme that you are presenting. Your Honor, my name is, together with my co-counsel, we represent the state of Texas in today's case. The state has charged the defendant with the offense of theft. The evidence will show that the defendant, blah, blah, blah. We will call 3 witnesses today who will tell you, blah, blah, blah. At the end of today's trial, my co-counsel will stand up and ask that you find the defendant guilty of these charges, because we believe at that point that we will have proven the offenses beyond a reasonable doubt. Always end with what you are going, what you want, what you're going to ask for. Opening statement script. Judge says, the court will hear opening statements on behalf of the state. Prosecution makes their opening. Judge, does the defense wish to make an opening statement at this time or wait until the conclusion of the state's case? defense chooses. We'll wait, Your Honor, or we would like to make opening statement at this time, Your Honor. All of these scripts can be found under Rules of Procedure, the very last few pages. I just copied it there, and we're going over the script that's found at the end of Rules of Procedure. So judges, if you want to print out those last few rules or have all of it printed out, that's probably important, but flip through that script as you're going through the trial, and you can. After opening, we get to the prosecution or plaintiff's case in chief. Prosecution will call their witnesses to the stand and will conduct direct examination. So with witness one, prosecution conduct direct, defense will have a chance to immediately conduct cross-examination. After the prosecution calls all their witnesses, they will rest their case. That means they're done presenting evidence. Defense is the same as above. They'll call all three witnesses. As they call a witness, conduct direct, the prosecution can cross. At the end, the defense, when they've called all three witnesses, would say that they rest their case. Here's our script. Judge says the court will hear evidence on behalf of the prosecution. State, you may call your first witness. Your Honor, the state calls Officer Hines to the stand. Judge, after that's done, the judge then says, defense, you may now conduct cross-examination. Defense conducts cross. Judge can allow for a redirect. So direct, cross, prosecution redirect, and then defense can recross. That process is repeated for the remaining prosecution witnesses. And then, like I said, when all the evidence has been presented by the prosecution, the one attorney would then stand up and say the prosecution rest. Repeat the process for defense's case in chief. Let's talk about those specific elements. What's direct examination? So the attorney will call a witness to the stand. It's their witness. It's your student from your school. Your Honor, the state calls Officer Hines to the stand. Be authoritative and direct when you're making that statement. In prepping your questions, you might have that at the top of your questions for that witness. Have it say specifically, Your Honor, the state calls so-and-so to the stand, so that you don't have to think up that phrase. It's right there on the paper for you when you're calling that witness. The attorney will ask witnesses and also decide which order you're going to call your witnesses. You don't have to call them in the order that's been provided to you. That might be the best way of calling them, but it'll be up to you in what order you want to call them to tell your story the best. The attorney will ask the witness questions based on the information provided in the case materials. You're trying to pull facts that prove your team's position and make your witness believable. Some question examples. Tell the court what happened when you entered the room. That would be assumes facts not in evidence if we didn't already know that they entered the room. So the question before it should have elicited the fact that they entered a room. What did you see after the defendant broke the vase? How long were you at the restaurant? Examination, you're questioning the other side's witnesses. So you want to explore weaknesses in their testimony by pointing out bias or contradiction or bad facts that are in their affidavit. For direct examination, the witness is the star. You're asking the questions, but they're the ones telling the story. You want all the attention on the witness. For cross-examination, the attorney is the star. You are the one who is presenting the argument or making a statement in the form of a question. And you have the witness agree or disagree with you. Generally, pick 3 cross points per witness and set up points in a strategic way for questions in a strategic way for each of the 3 points that you have that you're wanting to prove with your cross-examination. Sample question, isn't it true that? Wouldn't you agree that? Wouldn't it be fair to say? I think we might, for some of you who have been watching a famous trial, you might be tired of fair to say. There's a famous trial happening right now that a defendant keeps using fair to say a lot. You make a statement and then end it with correct, and make a statement and say, isn't that right? Those are all types of cross questions. Redirect, the original attorney will attempt to rehabilitate their witness with follow-up questions. You can prep redirect if you know some of what the cross questions are going to be. Rule of Evidence 611. So redirect is limited to matters that were brought up on cross. You can't bring up anything new. It has to be things that were discussed on cross-examination. Recross, the opposing attorney attempts to attack the rehabilitation. Again, this is limited. Recross is limited to matters that were brought up on redirect. You can't bring up new information. For closing arguments, the prosecution goes first, then the defense, then the prosecutor gets a rebuttal. Purpose of closing arguments is to summarize the important facts of the case, logically and persuasively lay out your arguments. You should be forceful, dramatic, and sometimes emotional. Always conclude with what you want. The verdict is after closing argument. The judge will leave the room and return the verdict of not guilty or guilty in a criminal case. For script, we'll go through those two. The judge will now hear the court will now hear closing arguments for the state. State provides closing arguments. That line should not be needed. We would like to reserve the remainder of our time for rebuttal. Sometimes you see attorneys throwing that in there as the last thing they say. It is reserved. If you have time left, you get to use it in rebuttal. Judge says the court will hear closing arguments on behalf of the defendant. Defense provides closing arguments, and then the rebuttal is provided, whether they requested it or not, they get it. And then the judge says the court will be in recess while I deliberate. Judge leaves the room. Bailiff says, all rise. Bailiff, again, when the judge enters the courtroom, says, all rise. Everybody stands up. While the judge is gone, you can sit down. I see a lot of rooms that I go visit where as the judge leaves to deliberate, people stay standing. And that sometimes if the judge is takes a long time, could be a while. So stand up if you want to, but you can sit down when the judge has left the room. Judge, for criminal cases, would the defendant please rise? I don't think that would apply to us this year. After hearing all the witnesses and reviewing the evidence, so the defense can rise, defense attorneys. After hearing all the witnesses, reviewing the evidence, I find the prosecution has or has not met their burden of proof. As such, either find the defendant is guilty or not guilty of the offense charged. For this year's case, we have two charges, so that will need to happen for both. As to count one, I find that the prosecution has or has not. Defendant's not guilty, is guilty. As to count two, has not, found the defendant guilty. So the judge can split those, can find the defendant guilty on one, not guilty of the other. Then judge says the court is now in recess. After trial, judge, this is super important, needs to limit their comments, especially if your district competition is running behind schedule, which it often does. If the evaluator talked a lot, you should talk just a little bit. So written comments are way more helpful to teams than verbal comments because they'll remember them. They can go back and review notes that you provide them later. So some ideas, judges, for comments that are helpful. You should probably study Rule of Evidence 611 before your next round. That's something very specific. They can go look at Rule 11 to study some objections before their next round. If a team didn't object at all, that's great advice to give a team, judges. Go look at comment, I think it's comment 2 to Rule of Evidence 611. There's several objections listed there that you can make. You might study that before the next round. Look at statement by party opponent, exception to hearsay. If you know they missed something, hearsay exception. If a team was very quiet, you can say, make your voice bounce off the back wall. It might seem loud to you, but it will be perfect volume as long as you can hear yourself and your voice bouncing off the back of the wall. Make sure you stand every time you address the judge. Those are all helpful comments. Generic comments that are positive might make them feel good. Y'all did great. I had so much fun that round. That was the best round I've ever seen. We hear that a lot. It's fine. Negative comments that are generic probably don't help. Y'all seem to not know what you were doing. That's not helpful. That's not helpful. If that is true, they already know that. and it will just drag them down even more if they hear it from their judge. So generic positive comments, fine, but if you're given negative feedback, make sure it's specific and helpful, like those examples I just gave you. All right, let's talk about score sheets. These are attorney score sheets. We won't talk about judge score sheets. Y'all can go look that up on your own. Attorneys, it's helpful to know how you're being scored, how you're being judged by the evaluator. Otherwise, you're just preparing stuff, hoping that it's going to be good, not necessarily knowing whether you're going to meet the criteria that's been provided to the evaluators. In preparing your opening statement, you can go through and say, did I provide a case overview? Yes or no? Did I identify a theme and theory of the case? Did I mention the key witnesses? Did I provide a clear and concise description of his or her side of the case? Did I discuss the burden of proof and state the relief requested? And then also, did I not use notes? At district, you're going to have a lot of opening statements being presented with notes. It's fine at district. At state, you might try to get away from notes, but the evaluator will still count you off even at district if you're using notes on opening. But it's more common because everyone's getting used to the case. So you can also, there's a little hint, you can key your evaluator into the fact that you know what you're supposed to be talking about by mentioning some of these things. So you don't want to come out and say theme or theory, but it's clear what theme or theory is. You can say, I've got 3 key witnesses today. You can say, let's talk briefly about the burden of proof. So you can mention the things that are provided in your score sheet in your opening and closing if you want. But go through, make sure in cross you're asking only leading questions. You are ready to control story development. In your closing argument, did you do these things? So points here are important to note. There's 50 points to a perfect score. It's not what you're striving for, but that's the ultimate. If you get 50 points, that's a perfect score. You get to 50 points by getting 5 points at a time. Opening attorney, the attorney providing opening can score up to 5 points. The attorney in their direct examination, whether they have 1 or 2 witnesses, will get 5 points across, 5 points per attorney, and then in closing, 5 points for attorney. The attorneys can get each 5, 10, 15 points apiece. They're responsible for 15 points apiece. The witnesses are each responsible for their own 5 points, so 15 total, and then there's an overall team performance. So each attorney is responsible for 15, 30 total, and then the other 20 come from the group performance and the witnesses included in that. Here's what you need to do to get 5s. Here's what you need to do if you want 4s, all the way down to 0. Your evaluators are going to be told to start at 3, average, and go up or down from there. So if you are just average, you don't wow them, you don't meet above average or excellent, then you'll get 3s. If there's some stuff you need to work on, it might go below 3. All right, we are going to talk through bailiff, but I want to make sure everyone needs to know bailiff responsibilities, but I will get to some fun common objections once we get through the bailiff stuff. So attorneys and judges don't leave just yet. And then also a quick note as we chat, nothing in any training overrides the rules of evidence or rules of procedure. I've attempted to make sure that everything I'm saying is in line with rules of procedure, rules of evidence, but you can't like take a transcript of this training and say, well, you said. It's up to your judges to make findings, to make rulings on rules of evidence. And then obviously the district offices get involved if there's an issue with rules of procedure issues that you have questions on. So that's the disclaimer for the whole training. All right, let's get into bailiff, and we've got some math ahead of us. All right, what's the job of the bailiff? They keep order and they keep time. They keep order mainly by the all rises when the judges leave and and enter the room. If somebody gets out of hand and the judge orders them in contempt and bangs the gavel. Here we go. Oh, my gavel's not going to come through unless I put it in front of my nose. There we go. Bangs the gavel. Then the bailiff would escort them to jail if the judge holds them in contempt. We don't have youth and government jail, though. What we're going to talk about, though, is keeping time. Keeping order, that's in the script. Bailiffs, you can have the script if you need help with that. It's found at the end of Rules of Procedure. We're going to talk about timekeeping and math. So bailiff, here is your timekeeping worksheet. You'll write just your name, the trial number, prosecution team number, defense team number, gather that in pretrial. Then through here, you're going to write the minutes used and how much time is left. I'm going to show you one example of how to keep track of time. And so for opening, both sides get 2 minutes. For direct, in total and redirect of all 3 witnesses, they get 18 minutes. For the cross-examination, you see I crossed over here, the cross-examination right here of the 3 witnesses, they get 15 minutes. After direct and cross on each of those witnesses, we'll go up to here. The defense direct, they'll call their 3 witnesses. The prosecution will cross all of those witnesses. So it's across the score sheet. And then we have closing arguments, 3 minutes. 1 of those can be reserved or used for rebuttal. And then defense has 3 minutes outright. They don't get a rebuttal. It's 3 minutes all at once. So let's talk through some examples. Note down here at the bottom, time will not stop for objections. The teams each will have 2.5 free minutes that can be used anywhere. They must notify the bailiff pre-trial where those 2.5 free minutes are going to be used. So this is an example of allotting those 2.5 free minutes. That's our step 1. So here they used 2 minutes for prosecution for their direct, and they put 30 seconds on cross. The defense here just decided to add all 2.5 minutes to the their cross-examination. Step 2 is timing. So we start here. I missed a slide, but that's okay. We can recreate it. So in the direct, if under this timer, you see here, there's direct of witness 1. The prosecution used 8.5 minutes of their 20 minutes total, and which gives us 11:30 left. So I said how much time was used and how much time is left. From the direct, we went down here to the cross-examination. That's where this timer now shows us. The defense used 5.5 minutes on their cross of prosecution witness 1. We write down 5:15, subtract that from 7.5, 7:30, and that leaves us with 12:15. Yes, 12:15 left. Have your iPhones, if you need it, on airplane mode to help you with the math too. From there, we'll go back up for redirect of that same witness. The prosecution used 30 seconds. We just take that off. That's an easy math. Taking 30 seconds away gives us 11 minutes. We come back down here for recross. They used a minute, which is also easy math. So 12:15 down to 11:15 left. We go on to witness 2. The prosecution used 5.25, 5:15. I think that math might have gotten off there. So subtract that out. And then we jump down to recross. They used 3 minutes. Subtract out 3 minutes, we get down to 9:15 remaining. I've shown just with an X here that there was no redirect, which also means there was no recross. On direct of witness 3, 5 minutes were used, which gets us to 1:15. I think that should be 6:45 and 1:45. So my math was off when I created the slides, I think. On the cross of the third witness, there was 7 minutes used, and that should reflect 2:15 left, not 9:15 left, because 9:15 minus the 7 minutes. And then I'm showing here that they ran out the clock. So if that was 1:45 left, they would have used the 1:45 and had 0 remaining. So bailiffs, if you have questions about timekeeping, you saw I made at least one mistake on mine. If you have questions about how to count down, make sure your judges have gone over that with you. Judges at district, especially rounds 1 and 2, make sure you're going over that your bailiff knows how to keep time. And if you're not fully confident that your bailiff knows how to keep time, then I would follow along with them, keeping your own time. Prosecution team is supposed to bring their own bailiff. Prosecution in the round is responsible for bringing their bailiff, whether that is an advisor or a defense witness that's not also a prosecution witness. All right, ruling on objections. We're going to go over some new instructions for evaluators that affect our judges, some common objections, and then close it out. Basic guidance for judges. I don't have a slide on that, but it's if you agree with the objection, then it is sustained and they cannot ask the question or present that testimony or offer that exhibit. It won't come into evidence. If you disagree, then the objection is overruled and the attorney can ask the question again, or the witness can answer, or the piece of evidence comes into as an exhibit 1, 2, 3. What else there? Attorneys, if there's an objection, and if you're objected to and you win, it's overruled, go ahead and re-ask your question. If you don't believe the witness knows what the question was, if they've forgotten the question. All right, new evaluator instruction. This is quoted from the evaluator forms or their training. Judges, this is important for you. Judges are to keep the trial on schedule as they are the timekeepers. If a judge allows for multiple rounds of back and forth on objection, may I have a response, 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 then the judge will be counted down. If the judge allows multiple rounds of back and forth, you're going to be counted down as the judge. Excessive time spent arguing over objection hinders the presentation of the attorney's cases. The judge can't stop an attorney from objecting, but they can make a ruling within a reasonable amount of time. Most objections should only require one response from each side before the judge rules. Judges, that's a big change. We're used to saying objection, response, 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 response. So this year we should see objection, state your grounds, response, maybe one more response, and then the judge rules. If it's a 6-11 objection, most of those don't even need a response. Objection leading, sustained, or overruled. There shouldn't need to be a response on most of the 6-11 objections, which we'll get to what 6-11 objections are. So judges, that's a big change, but it puts the burden on you to make sure that attorneys aren't bogging down the time in use of objections. Attorneys, the evaluators have been told that if you excessively use objections to the point where you're not allowing the other side to present their case, then you'll be counted off. If they're good objections, hopefully the evaluators would take that into consideration. But be wary, make sure you want the evaluator to know that you know what the rules are, rules of evidence, and know how to make objections. But you don't want to overuse your objections. All right, we'll get through some common objections. Rule of evidence 6-11, what I just talked about. First is narrative, an open-ended question that is too broad in scope and allows the witness to add additional information that's not asked in the question. What happened on July 1st? Well, around the world, lots of things happen. Let me tell you about something that happened in India. So it's just very, very broad. Tell me about the accident. It's open-ended. An answer can also become narrative if a witness begins to ramble on and on and on. The objecting attorney would say, objection, the question calls for a narrative answer, or objection, the answer has become narrative. Non-responsive is when the witness does not answer the question that's asked, or the answer goes beyond the scope of the question. They ask about one thing and the witness has answered it, but then they keep going about something else, or their answer never answers the question at all in the first place. The questioning attorney is normally the one objecting. So you're the one asking the question. You would object, say non-responsive. I would ask that the court instruct the witness to answer the question. Practice tip, be careful on using this objection. You are signaling to everyone in the room that you've lost control of the witness and need help from the judge. So it's not good to lose control. If it happens, it happens. Some witnesses are very difficult to get them to answer basic questions, but they've taken an oath to tell the truth. That's the reason that they're in trial, is to provide testimony and evidence. So ask the judge for help if you need it. So here's another option instead. Try this. Mr. Jones, I'm not sure you understood my question, so I'm going to ask it one more time. If they fail to answer the question again, this signals to everyone in the room that the witness is being uncooperative. It'll lower the witness's credibility. Sir, I'm not sure you understood my question. I'm going to ask it one more time. It's very powerful. All right, compound question, just two questions thrown together. Did you or anyone else see the accident? Yes. Well, which one? Was it you or was it someone else? Objection, compound. Ambiguous, a question that can either cannot be reasonably understood, you can't understand it, or one that is capable of being understood in more than one possible senses. After the cat caught the mouse, did it die? Did the mouse die or did the cat die? Subjection, ambiguous. Or the question is just rambling is another example. Objection, ambiguous. Asked and answered, the attorney repeats a question that has already been asked of and answered by the witness. Normally that happens in cross-examination. The objecting attorney's witness is on the stand and you believe that the witness has answered the question and the attorney just isn't happy about the answer that they've gotten, so they ask it again and again and again. Objection, Your Honor, the witness has already answered this question. Or objection, Your Honor, asked and answered. Argumentative questions that attempt to elicit an argument, to summarize or comment on the evidence. It does not seek new information. The objection is not to be used just because an attorney raises her voice when asking a question. This isn't the one for that. So example, how can you remember what happened on October 10th when you can't even remember what happened on the 11th or 12th? It's just argumentative. You are guilty, aren't you? The objecting attorney would say objection, argumentative. Assumes facts not in evidence. This is another attempt at an attorney attempting to testify in their questions. The question contains a statement of facts that have not been presented by a witness or an exhibit. So that's the example I gave earlier. After you walked into the room, what happened next? Well, if there was no evidence to suggest that they walked into the room, then the attorney in the statement is providing testimony, and they're assuming facts that have not yet come from the witness stand, from the witness chair. Badgering or harassing, this is raising their voice. So an attorney is not allowed to raise their voice or express improper emotions when questioning a witness. The trial judge will decide if that conduct is impermissible or permissible. That's badgering or harassing. Objection, the attorney's badgering the witness. Going backwards to 402, this is relevancy. Only relevant evidence is admissible. Evidence is relevant if it is of any consequence to the elements of the case in light of the actual law that the prosecution is claiming that the defendant violated. So go back to your charging instrument in the case. And is the evidence that you're eliciting helpful or hurtful to either side, then it would be relevant. If the attorney believes it's not, they would say objection. Evidence is not relevant. If the evidence provides any weight, any value to an element of the offense or credibility of a witness, then the evidence is relevant. Objection, lack of personal knowledge. A non-expert witness must have personal knowledge of the testimony they are providing. This objection could often be used along with hearsay, where a witness is testifying not based on their own knowledge, but on what someone else said to them. So so-and-so said something to them that's going to be hearsay. They're testifying as to what somebody told them. They also don't have personal knowledge of that particular thing. For judges, my favorite judge response to lack of personal knowledge is, if they don't know, they can tell us. So if the witness doesn't know, they can tell us. If the lack of personal knowledge isn't clear, isn't clear from the context, you can overrule the objection and tag it with that saying. So if it's clear that they're testifying on something that they lack personal knowledge about, you can go ahead and sustain it. But if it's something that we often see, like, that's not in their affidavit, they won't know that because it's not in their affidavit, then I love the overruled. If they don't know, they can tell us that they don't know. Impeaching a witness, Rule 607. The purpose of impeaching a witness is not to force the witness off the stand or to make them cry, but rather to challenge the testimony provided by the witness or the actual witness themselves. If impeached, the witness remains on the stand. The questioning attorney doesn't need to make a formal declaration of impeachment. I declare bankruptcy. There's no need for that. A witness can be impeached by, here's some examples. All of these are found in a comment to 607. The most common impeachment is they said something in an affidavit, and then today they're saying something different, and you are pointing out the fact that they have a conflict in their testimony. If you need help on how to impeach a witness, ask a friend or me at state. We can walk through impeaching. All right, 702, expert witness. Before an expert witness begins discussing their opinions in the case, the questioning attorney must lay a foundation for why this witness should be qualified as an expert. The attorney should ask the witness questions about their knowledge, skill, experience, training, and education in whatever the area is that the witness is supposed to be an expert in. After the foundation has been laid, the attorney will say, Your Honor, we offer the witness, Mr. Jones, as an expert in the field of, state your field, aerospace engineering. Judge, tip here, write down the field. Don't go any further until you have the specifics of the field written down on a piece of paper, because you're gonna have to come back and say them here in a second. So take time to write them down. Opposing attorney may say, we object because opposing counsel has not laid sufficient foundation to show that Mr. Jones is an expert in this field. Lack of foundation. If the judge disagrees, they can say so, objection overruled. Mr. Jones is now considered an expert in the field of, and then read what the field is off your paper. In the field of aerospace engineering, you may continue your questioning. If the judge says sustained, or if you're allowed to provide a response in response to the objection, then here's a practice tip for you. So if you plan to offer a witness as an expert, write out those areas under 702, those knowledge, skill, experience, training, education, the ones that apply to this witness. You don't have to meet all of them. You don't have to meet 3 out of 5. There's no rule like that. Those are just ways of showing that the person is an expert. It's up to the judge to decide if they are or not. But write down the areas that you think your witness meets, and beside it, the reason why you think the witness meets those areas. Then recite that area back to the judge and show that, this witness is qualified. When we talked about his education, he told us this. When we talked about his training, he told us these classes that he's taken. When we talked about skill, we said he's performed this procedure 20,000 times. Hearsay, fun. Hearsay is an out-of-court statement offered for the truth of the matter asserted. So it's a statement not made in court that is offered as truth. A statement verbal or in writing, or a gesture that conveys a meaning, not made in court, even if it's by the witness on the witness stand. It's not made in court. It's made before the court date. That is offered as truth, not for its impact on the hearer or some other reason. So if it's offered for some other reason, it might be fine, but it's a statement not made in court that is offered for truth. I would memorize this: hearsay is an out-of-court statement offered for truth of matter asserted, so you can use it in your responses or objections. Just memorize the definition of hearsay. All right, if the question or answer contains a statement from someone else or this witness's previous statement, you should consider objecting to hearsay. So-and-so said, object. If there's a question, what did they say? Objection, hearsay. What did you talk about? Objection, hearsay. Sam told me X. Objection, hearsay. Veronica yelled loudly. Objection, hearsay. We're going to go through some exceptions or exemptions for hearsay. One is not offered for truth. I alluded to this a second ago. Your Honor, the statement is not offered for the truth of the matter asserted, but rather to show ... rather to show the knowledge of the hearer. If it's important that this statement was conveyed to a person, then it might not be offered for truth, but rather for the fact that that person heard this person say it, or offered to show context for the action of the hearer. If the defendant is on trial for murder, they killed somebody, but they claim it was self-defense because the victim said, "I'm going to kill you," and the defendant said, "No, I'm going to kill you first," acting in self-defense. Then that statement from the victim, who the defendant is claiming was the aggressor, the statement, "I'm going to kill you," would not be hearsay. It's not offered for the truth because he didn't actually, in fact, accomplish the fact of killing him because the defendant killed the victim first. It's not offered for truth, but rather it's provided for context of the action of the person who heard the statement. Hearsay is fun. Prior statement. So a witness's prior inconsistent statement, think impeachment with the affidavit. Statement by a party opponent. It's not hearsay, Your Honor. It's a statement by a party opponent. The statement is offered against an opposing party and was the party's own statement. So statement by the defendant. The defendant made a statement if offered by the prosecution. Present sense impression. A lot of these we might not see on every single case, but we'll go through a couple of them. So a statement that describes something that is happening while the statement is being made by someone who is watching the event. Somebody says, "Wow, look, the red truck is running. That red light. Oh no, they collided with the white car. Or, wow, look, it's raining outside." That's a present sense impression. It's something about an event, and I'm describing the event. Statement here might also be considered an excited utterance, this red truck colliding with a white car. Excited utterance is a statement related to a startling event, a shocking event. The attorney soliciting the testimony must lay a foundation for why the event was startling. Big John just stabbed little Sue to death. That's an excited utterance. Somebody who just witnessed this awful event made right after they saw it happen. Then existing condition is a statement that describes the declarant, the person who's making the statement, the declarant's mental, emotional, or physical condition. I'm so sad right now, mental condition. My leg is missing. That's a physical condition. I'm missing my leg. All of these are not hearsay, even though they're a statement, out-of-court statement, offered for the truth of the matter asserted. These aren't hearsay. They can come in. Your Honor, it's not hearsay because it's a then existing physical condition, statement of the declarant's physical condition. You might also have statements of related to intoxication that could count as a statement of the declarant's mental condition. A business record, a record made by somebody because it's their job to make the record. There's a few foundation steps that you have to lay. All of those questions are found in 803.6. Moving away from hearsay. Rule of evidence 902, this one's important for us. Self-authenticating documents. The death certificate in our case is self-authenticating, meaning it doesn't need to be presented by a sponsoring witness or any questions asked. An attorney can even offer it pre-trial because it's self-authenticating under Rule 902. If I were you, I would, for prosecution, put it in right after your opening statement or right after calling your first witness. Rule of Evidence 1003, stray marks, copier ink marks, hole punches do not cause an exhibit or affidavit to be inadmissible unless the alteration changes the meaning conveyed by the document. You can't object to exhibit because it's got hole punches. That's just not fair. All right, I think that's all that I have. Let me see if I can go. Nope. I will end it there. So like I said before, find me at state or district competitions, or reach out through the state office if you have any questions or need anything from me. Hope to see you all very soon down in Austin. Good luck at your district competitions and have fun. Bye.